Sunday. Hakim, Ọmọjọbí, Mr. Yinka Ṣóníràn. Second, the master present. Eleventh defendants present. Others are absent. Yes. Yes. Who are you? Who are you? Who are you? Who are you? Are you a party? Eleven. What is he saying? Speak up. Registrar date. Party shall attend PTC on 21/10/2024. This year, 3/6/2021. Chief Moshood from Ochoya. Chief Adégbénga tó bá jò. Mr. Kamilu Owóyẹlé. Mr. Musibau Ṣakíoyè. Mr. Tajudeen Adébísí Ọ̀ṣọ́. Kẹ́hìndé Dòsùnmù. Sodiq Dòsùnmù. Táíwò Awóbàjò. Tósìn Awóbàjò. Ganiyu Lateef. Àmọ́rù Anífowóṣe. I love classes absent.
Representation?
Yes, sir.
Thanks.
21
Example 21:10. Hearing necessary.
That's possible. I don't know why I'm trying to possible. HT 319-2017. Mrs. Olówótípẹ̀. Alhaji Muhammed Alao Dada. I love classes absent.
Representation? Yes. Yes. Registrar, did you receive the report? Registrar, report in respect of this for transfer.
I'm sorry, I need a copy of it.
Can you check?
So,
Can you check the high quarters?
There's no, sir.
no problem. This is my profile business.
Yes, we also have received a copy. When was that sent? What's the date?
That's the 9th November.
9th November. Can I have the file? And what does it say?
You see the order that the matter is passed.
And why don't we have a copy?
So this is my own copy sent to the registry.
Right. Are you sure it's not at the registry? Can you take that and go and find out? Please you sit down.
Also, by the way, that you not give me a copy of the report. This is fine.
Please you sit down.
I don't know what saying.
Is Mrs. Popola there? Please go to the registry with that. Yes, please with that letter to find out. Next one.
This year, 1722. Mr. Adebayo, Mr. Shola Olamiro. Hello, Finance Professor.
Yes. Any representation?
I remember that.
Yes.
Yes, sir. Hello, 29, sir.
Please adjourn to 2019. Register. Next one, please.
Sir?
Next, please.
Yes, sir. Hello, my level of what is sir? It's the 2024. It's not limited. I do not you know what?
Parties?
Finance Professor. Defendant absent.
Any representation? Yes.
Yes, my lord.
2019.
Sir. Yes, sir.
Your matter has not been called.
Yes, sir. It's a remote situation.
But you should still call it so that I can write something down.
Hello, number 6 on the first system. This year, place 118. Mr. Washebu Oshogare versus Latif Chukwuemeka. Hello, parties absent.
Right. Yes. Right. Right. Another date then for report.
Hello, 21 cents, sir.
Adjourn to 2110 for report of settlement.
And then number 12 from the first system. This year, 205-2025. Mr. Akinola Shogoye. Yekini Tunde Shogoye. Adesola Fadilat Ayola Wasiu Ologun Shogoye.
Is it Shogoye or Shogoye?
Shogoye, sir.
Parties,
Parties absent, sir.
representation. Eight.
About 29 then, sir.
Did you find it, Mrs. Popola? What? Right. Okay. Right.
I got number 13 of the person, sir. ACS 295-2024. Mr. Abayo Bunoloku. Mrs. Esther Abose Deoloku. My petitioner present, sir. Tenant is absent.
Alima? Yes.
With due respect to this honorable, I've been part of community. Been part of community.
Karim?
Yes, ma'am.
Yes. Next council. What?
The respondent in this matter is not within the definition of income. It's outside the country. People are solid. I had that confidence last week Wednesday. I don't think it is acceptable and not because examining the petitioner, since the petitioner and the respondent, what the two of them are asking for is to resolve the marriage.
How about the children?
They were not happy that the children of the marriage should be with you.
Did you file a report of compulsory conference?
No. What parties are getting that the children of the marriage deal with the petitioner and the mother should be living off the assets. That's what the plans is.
But you don't have, you haven't met, and you haven't filed anything. If you want the court to incorporate that in the judgment. You ask that the petition be dismissed. There is also the issue of settlement of property. Right? Then you can answer for the petitioner.
Petitioner should have
Where is that? Have you filed anything?
We are able to file. For-
Yes. Parties to file before the formal contest.
All 29 things.
What date?
29 things.
Please send them to 29 cents. On the hearing.
Hello?
Yeah.
Still on the two members.
Right.
The pregnant service is coming from the wedding. That came from this morning. Or we came from this morning. But yeah. But it doesn't take more than 40 minutes from the wedding in this place.
Right, I need to run through my matrimonial list before I can get back to the criminal ones.
Sorry about this.
Yes, next one.
Yes, sir. I don't know about 14 is for tomorrow, not today, sir.
Okay,
Yes, sir. Number 15 of the first.
step that down, please. Step it down, is it
Yeah.
not for judgment?
Yes.
Yes.
Number 16, sir. ACS 5124. Mrs. Ijoma Larry Isaac. Mr. Atule Larry Isaac. What's your name? Come on, please.
Yes.
Petitioner present, sir.
Yes.
To participate in the emotion, I see. Yeah, that's the last question.
Yes.
So, this matter is really good to try to this. Also, this is the comments. Not going to do it. What time?
And the children?
Not that person. No property.
ACS 05-2023. Mrs. Ayotunde Shalewa Apipo Awe. Mr. Lamidi Daniel Apipo Awe. My Lord passes absent, sir.
Any representation? This is struck out.
I thought. I know number 18 on process, sir. ACS 119-21. Mrs. Amoluwa Oluwa Fayope Lawal. Mr. Oluse Ayotope Lawal.
Olusegun or Olusegun?
My Lord is Oluse, sir.
Right.
Passes absent, sir.
Representation?
Oh, the second is. It's oh, I'm going up. Well,
Right.
Maybe this time.
Yes.
So, okay,
I did. Yes. My name? Name? Right.
There's no the process, the proceeding anymore. The only bank that is standing in the standing IBTC Bank PLC, which is the respondent to the application dated the 19th day of 2004.
Originally, were they in and have they been discharged?
Yes, they were checked last week when it was the order setting aside that order with respect to the attachment of the sum of something thousand in the first 19.
When the court made an order,
The court made an order on the 14th day of May. On the 14th day of May 2004, it's court made an order discharging the other damages which are the first bank, first bank PLC, and first lending.
right.
The court had acknowledged for continuation of the proceeding. Before the court are three applications brought to. One is a notice of motion dated 11th day of January 2023.
11th.
11th of January.
Yes. Yes.
The other one also dated 13th December 2023 was filed on the 28th of December 2023.
Right. And I cancel for the judgment letter. Registrar, have you opened the applications?
Yes, sir.
The second date is filed on 28th of December 2023. Was dated 13th of December, filed on 28th of December 2023. First one.
The other one? Is it the 13th of December? Is it the one filed 25th of January?
Well,
The other application of the 28th, no, 13th, filed 28th.
Yes, ma'am.
Yes, ma'am. This is the 28th December.
Yes, 28th December.
I filed 20th December.
Oh, it's dated 13th December, filed on 28th of December 2000. The date of the application is 13th December 2000.
And
Filed
filed
28th of December 2000. The first one dated the 11th day of January 2005, 12th day of January.
did you find it?
Yes, I'm not.
What? You sent me?
Yes, sir.
As long as the mission filed on 28th of December.
I think there was a mistake of dates. I was waiting until December.
What is the motion for?
Well, the motion for one filed on 12th day of December. It's the first reading is praying for
Application of the one of the 13th of December.
the
The one of the 13th of December.
13th of December.
The 13th of December?
So there's no 13th.
There's no 13th. The 28th.
Yes, the one dated 20 and filed 28th December 2000. The first reading then.
There is no application of 13th.
No, there's
It's
no.
filed 28th December. Application of 28th December.
Yes, ma'am.
Filed when?
It's filed that date.
Because I have the one I have here, I have 25/1/24 on it as a date of filing.
No, sorry. The date is filed, 28th December.
This one has 25/1.
Yes, sir. I think if they can write it down, this is on stamp 26th December. Yes, sir.
Thank you. I'm good. Well, I also see to be the other one. Filed on the 12th of January 2000.
That's as well. Let's sort out.
So the application for what is the one dated 20th day of June 2004. I'm filing the 20th day of June.
On file,
Filed on the 20th of June 2004.
and what is that for?
What is an order this was appointing the responding that's happened that it is LT, the custodian trustee of the moving in his custody. No, I'm not saying the I don't know that
Date for hearing of the application. Date for hearing of the application.
Hello. 1510.
Case agent to 1510.
That's possible.
I wish my Lord very rest.
Thank you. Next one.
Number 19 on hospital. SCS 101-2016. Mr. Rotimi Sumonu Adams. Mrs. Omolara Lady Sumonu Adams.
That is
Parties absent.
representation.
NG and what? NG and what? And what is spelled ANIGPO. I'm going to the print of LG. Okay. LG. Okay. Our humble appearance.
Yes. And what is it for? And why do you want virtual hearing? Why do you want to be heard virtually? Proof of service? Proof of service?
No, sir. No, sir.
No proof of service. No proof of service of the application in the file. Date. Hearing notice to issue on the response.
My Lord, 29.
Adjourn to 2019. Yes.
My Lord, number 27. SCS 73-2021. Mrs. Oluwakemi Esther Olukomo. Mr. Olayinka Babatunde Olukomo. Parties absent, sir.
Representation. This is struck out. Dr. Pastor, you may mention your case.
So the first one is the state of Akinola, the doctor, number 3 of the constitution. Our submission is
Right, on with all the case, please. Right.
Hello, number 3 on hospital. ACS 2020. The state Akinola Teletope. Tenant absent, sir.
Representation. Yes.
Hello, Dr. Pasi, for the defendant.
Dr. Pasi AO. Yes.
Appearing with me, James O. or more and P.O. Happy David Oscar from Hamlet.
Yes.
Hello, submission is that it takes approximately 40 minutes to go to account for the wage. And the court has been sitting for about an hour and a half. And before the court,
So we will give a further date.
yes, sir.
Date. Is it for mention or for hearing?
No, it's for hearing.
Another date for hearing.
Yes, sir. Not the they are on their way. They are still on their way.
Another date.
3010 3010, sir.
3010 for hearing. The other one.
Second number 5.
Hello, number 5, sir. SCS 14C2020. The state Joy Okore, Kate Ujoku, Uju Favor, Paul Mary, Chukudi, Titi, along with defendant absent, sir.
Same appearance. Yes.
Same appearances.
Yes. Yeah, for all the defendants.
Not for
Which one?
but the court error.
Same appearance for all the defendants. Yes.
Yes,
No, there's nothing I can do. I already have other matters to do. What do I want to do now? I still have other matters to do. I'm not even sure I'm going to be able to get to them. This is to them. Registrar, which other matter is to them?
Number 2 is student, sir.
Number 2,
Yes, sir.
the application. How about number 9?
Number 9 is also
What is it for?
for
Is that the one? The one to
yes,
the
sir.
registry?
We're going to check.
Have they been able to find anything?
No, sir.
Yeah. It's Mr. Muiwa, yeah.
Yes, I went along with the registrar. Said that the problem down later was addressed.
Can I see your, can I see the, please recall the case?
Yes, sir.
Can I see your Can I see your PR?
This is all. ACT 1916. Mr. Francis Olowodipe, Alhaji Mohammed Alao Dada, Partisan President.
Yes, can I hear you? Let me transfer.
Yes, I went to the registrar.
Appearance?
Yes. AA plan.
Yes.
Yes. I went to the registry. Moved to the registry. Yes. Okay. Yes. Hold on. Yes.
Please ensure that you file a copy of this before you leave today at the registry. File a copy of this. Case file is hereby transferred back to the Hotel Judicial Division under the Piato Honorable Chief Judge, dated 6 November 2023. How many matters do that?
Yes, I have three.
Call the matrimonial board.
Yes, I do.
Always take it to the end of the.
Civil.
Yes.
Number 16 on the SKS 124. This is Geomanda Isaac. Mr. Abimile Dario Isaac. My love, Dr.
That's good. I don't know what I'm missing. Good question. That's okay.
Petitioners, please. Yes, your judgment will be ready.
How long will that be the next? Are you interested in this? Please take it right. See, I can add to make sure that I so we believe you reduce that the evidence has shown that the evidence has shown in this case, what is honorable for can be the truth, can be the truth, and not the truth, nothing may be true. So let me go. So help me. You are hereby cautioned to tell and your testimony. I will fully receive this story. You are likely to be said and family. My Lord, goodness on you by text in English language and caution according to section 206 of Evidence Act.
Right. Yes.
It's not this honorable, but your name, address, and what you do.
My name is Mrs. Larry Isaac Idiola. I live at 301.116.
It's really mine. I know this right.
Repeat the address.
301. No, 401. 401.
Yeah, there's.
The that's the address. 401. Block 1. Lot 3. All this.
Yeah. Yes.
You know the respondent is.
I know him. He's my husband.
Yes.
Is he married?
Yes, sir. Yeah, I have.
See a copy of my certificate.
I will.
Does she mention where they got married?
Sir, okay, where did they get married? And where?
2004.
At, do you have any identification
Yes.
on you? I need your identification, please.
Do you have any identification?
Your bag?
People have cards and I name.
I'm going to send you back. I won't hear you. I need to have an identification for you to identify yourself. Who does that? The real petitioner.
Check with that. Yes.
In the meantime, continue. Continue in the meantime.
So the statement that marriage was contracted as marriage registry. See, but
When?
when? Means the when that.
You don't know when you got married? June when?
June year, this year.
June 2004.
Yes? What date in June? What?
29th.
You see why we need your identification. Can you give to the registrar what you have? Your NIN, your voter's card? You said you are a civil servant. What do you have?
I have my NIN.
Do you have your international passport on your phone?
No, ma. But I have my driver's license
Where is it?
on the show.
What's your date of birth? Your date of birth?
25th June.
Yeah, right.
Yes, sir.
Yes.
Can you confirm which you are married? Which you are married? Yeah. 2014. You see a copy of the marriage certificate. It's proceed.
The date on the certificate is 12th June. So we have 2 dates of marriage.
Which dates specifically?
4th June,
12 June when?
2004.
Married where? This is not the certificate they give out before you register. I'm going to, it looks original. I'm going to admit this, but we are going to verify this.
As a copy.
This is not the marriage certificate they give out before you register. What?
That is that one.
I need you to file our identification. I need you to file our identification.
As a purpose. As a purpose.
I have every reason to doubt that she's the petitioner.
What was the Bible? National.
Whatever order for verification of the certificate I give you marriage registry. Yes.
You remember that by the court registry, 7 special before. So find out that. See what you What one is going to do? Find out, like,
It's not even. Registry Lagos. It doesn't even have a police registry. It doesn't have that. I would say. Registry of marriage, not even the federal register. This certificate is big. I'm not sure the petitioners are. I'm going to step down this case. From the federal marriage registry, we. I have to step down this case before investigation. The court official shall verify the authenticity of the certificate and the identification and the identity of this witness. Step down. Date for continuation.
Yes, sir. 20. Taxi days, sir.
2010 for continuation.
Has gotten this.
Council, please meet with the court officials for logistics on how to verify her identity. She has to be taken for our biometrics. And then we also have to send this to the marriage registry. Because I've had so many from the marriage registry, even the federal marriage registry, even their CTC, we know how it looks. That certificate is not authentic until we. Right. Having done that, the criminal, they're still not here. I'm going to have to adjourn so that I can concentrate. I still have 19-page judgment to read, plus another 2 judgments to read, and I still have some other criminal cases I believe stood down. Can't be here. It's the end of the month and we're rounding up and preparing our judgments for the quarter. Okay. Exactly.
He states someone at the village
Not that. I'm going to read the judgments before I take the start.
ACS 14C2020. The state George Okore takes Undoku. It's no for Mary. My Lord, send that to our center.
Report for the second time. Is this the one? How many? Yes, council. State council. We have recalled this just again. They are still not here. Right. Registrar, please call the matrimonial for Mrs. Sudan. That is the second time, or the third time now.
The first time ago. The last time.
I'm doing this because she said she spent so much money.
I said it is better than 5 years.
Yes. I'm just about to adjourn your matter. Okay. Please call the matrimonial for judgment. Then I will come back for the land matter for judgment. We will take the criminal cases.
This year, 1924. Ogunbanjo Ademola Olalekan. Ogunbanjo Bidan.
Where is the records?
Yes, sir.
The record book.
Yes, sir.
What number is it?
Number, yes, sir.
Practice.
Approximately 600 people. I think it's kind of the Omoya is faithful FUYA. My appearance is
The name again, please.
hello. My name is Mayo Omoya. Omoya FUYA. Stop from Omoya. My appearance is I'm not afraid of you.
Judgment in the case of Ogunbanjo and Ogunbanjo. The petitioner Ogunbanjo Ademola Olalekan presented the petition before this court on the 19th of January 2024 against the respondent Ogunbanjo Vivian Nkendilin for dissolution of the marriage contracted on the 12th of July 2007 at the Federal Marriage Registry for Lagos State, Nigeria, on the ground that the marriage has broken down irretrievably. Particulars of the parties. The maiden name of the respondent is Nkendilin. The petitioner's given date of birth is the 12th of July 1974 in Oyo State, whilst the respondent's given date of birth is 8th of July 1976 and in Lagos State. The petitioner, a police officer, resides at B12 Ocean Crest Avenue, 22/23 Akogun Road, Oniru, Lagos State, whilst the respondent resides at House 42, Discovery Gardens Estate, Igbo, Lekki, Lagos State. Both parties are within the meaning of the act domiciled in Nigeria. The two children of the marriage, named Oluwaferanmi Nathan Ogunbanjo, male, born on the 14th of February 2009, and Adoluwa Nala Ogunbanjo, female, born on the 7th of March 2012. They live with the petitioner. The petitioner's proposed arrangement for the children is stated in paragraphs 5 and 6 of the petition. The petitioner pleaded circumstances and facts leading to the breakdown of the marriage in paragraph 5 of the petition. The petitioner seeks dissolution of the marriage on the fact that the parties have lived apart for a continuous period of 3 years, immediately preceding the presentation of the petition. The petitioner praised the court for a decree of dissolution of the marriage on the ground that the marriage has broken down irretrievably and the fact that the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with her, joint custody of the children. Evidence of the petitioner. The petitioner gave evidence that is an energy executive. It resides at B12 Ocean Crescent Avenue, 22/23 Akogun, Oniru, Lagos State. He testified that the respondent Ogunbanjo Vivian Nkendilin is his wife. Parties got married on the 12th of July 2007 at the Federal Marriage Registry, Koyi. The CTC of the marriage certificate was admitted as PW1A. There are two children of the marriage already named. They live with the respondent. The petitioner testified that the parties cohabited after the marriage at 1 Otubabakare Close, Alpha Beach Road, and they moved to B12 Femi Okunu, Phase 4, Jakonde, Lagos State, and House 15, Discovery Gardens, Igbo, Lagos State. The petitioner testified that the relationship was very toxic. They could not agree on anything. They were always at loggerheads on every issue, even on how to raise the children. Their constant quarrel and misunderstanding made their home unhealthy to raise the kids, and the petitioner had to move out of the matrimonial home. Both parties had a meeting at the instance of the petitioner and he informed them of his intention to end the marriage. The meeting degenerated when he informed them of the intention to end the marriage. The petitioner left the matrimonial home on that day. Cohabitation with the respondent ceased on the 26th of September 2016. The petitioner gave evidence that he has been responsible for the accommodation, education, health, and upkeep, welfare, and upkeep of the children. He urged the court to dissolve the marriage. All processes were duly served on the respondent, but she did not defend the petition. Learned Counsel Kayode Omoya Esquire addressed the court and submitted that the marriage had broken down irretrievably pursuant to Section 15(2)F of the Act. It is tried that the petitioner or respondent who presents a petition before this court that the marriage has broken down irretrievably under 15(1) of the Act must be able to bring himself within one or more of the facts stipulated in 15(2)A to H. And I have cited in the body of the judgment 15(2)A to H. Also see the case of Olorunfemi and Olorunfemi, where the court held that a petition for dissolution may be presented on the ground that the marriage has broken down irretrievably under 15(1), only if one or more of the facts in 15(2) is proved. Anioke and Anioke, Akinlolo and Akinlolo, and Nwakolo and Nwakolo relied on, or citation provided. Matrimonial cases are sui generis. The petitioner or cross-petitioner must give credible evidence in support of the claim that the marriage has broken down irretrievably. So even if the case is undefended, the petitioner must still give evidence to the reasonable satisfaction of the court that he is entitled to a decree of dissolution. See the case of Uzumaka and Uzoke, citation provided, where the court held that in the first place, the burden of proof in matrimonial proceedings is on the petitioner as ordained by Section 135 and Section 135 and 136 of the Evidence Act. Tamaluk and Tamaluk, Ibrahim, and Ibrahim, whether all relied on. As for the standard of proof, it is decreed by the prescription of Section 82 of the Act, which provides, and I quote, for the purpose of this Act, a matter of fact shall be taken to be proved if it is established to the reasonable satisfaction of the court, and where a provision of this Act requires the court to be satisfied of the existence of any ground or fact, it shall be sufficient if the court is reasonably satisfied of the existence of that ground or fact, or as to that other matter. The petitioner relied on 15(2)(f) of the Act. He testified and pleaded that cohabitation between them ceased on the 26th of September 2016, and he had to leave the matrimonial home due to their constant quarrel and misunderstanding, which made their home very toxic and unhealthy to raise the children. The petition was filed on the 19th of January 2024. From the facts and evidence before the court, both parties have lived apart for over 7 years. The evidence of the petitioner on the ground that the marriage has broken down is satisfactory and in line with the pleadings and Section 15(2)(f) of the Act. Where 15(2)(f) is proved, the court may dissolve without fault finding. See the case of Omotunde and Omotunde, citation provided, where the court held that the court has no discretion to exercise. The section has the absence of the fault element characteristic of matrimonial offenses. The law behind 15(2)(f), as far as living apart is concerned, is not interested in right or wrong or guilt or innocence of the parties. Once the parties have lived apart, the court is bound to grant a decree. See Ajidown and Ajidown also relied on. I find 15(2)(f) proved by the petitioner against the respondent, and when 15(2)(f) is proved, the court will not go on a voyage to find fault. As to the other matrimonial offenses pleaded, as the fact of living apart is sufficient for the court to hold that the marriage has broken down. On the issue of custody, the courts are guided by Section 71(1) of the Act, which provides that in proceedings with respect to custody, guardianship, welfare, advancement, or education of the children, the court shall have regard to the interest of those children as the paramount consideration, and subject thereto, the court may make such orders in respect of those matters as they think proper. Also, see the case of Oduche and Oduche, where the court held that when deciding the issue of custody, the trial judge exercises a judicial discretion, and in exercising that discretion, it should take the following into consideration: the ages of the children, education, welfare, general upbringing, arrangement for accommodation, the conduct of the parties. Indeed, the interest of the children at all times shall be of paramount consideration per Rule 5 or JCA. Also, in the case of Alabi and Alabi, the court also held that the welfare of the children is of paramount consideration, and the degree of familiarity with the parent ought to be taken into consideration. It is noteworthy that the ages of the children should be well considered before the court issues or awards custody. Also, see the case of Udogu and Udogu, citation provided, where the court held that if the parents are separated and the child is of tender age, it is presumed that the child will be happier with the mother, and no order will be made against this presumption unless it is abundantly clear. The contrary is the situation, e.g., immorality of the mother, infectious disease of the mother, insanity or cruelty to the child, for the JSA. The means and incapacity, conduct, and all relevant circumstances will also be considered. See Nana. There are 2 children named in the petition. They live with the respondent. The petitioner has given evidence that he has been responsible for all their needs. The court will make the appropriate orders taking into consideration the total circumstances of the case. On the totality of the evidence before the court, I hold that the petitioner has proved his case pursuant to 15(2)(f) of the Act to the reasonable satisfaction of the court. A decree NISA is hereby granted, dissolving the marriage between Ogubanjo Ademola Olalekan and Ogubanjo Vivian and Kemdilin, which marriage was solemnized on the 12th of July 2007 at the Federal Marriage Registry, Lagos State. The decree NISA shall become absolute 3 months from today. There is no contrary order of this. The respondent shall have primary custody of the 2 children of the marriage. The petitioner shall also have unfettered access to the children. The petitioner shall give prior notice to the respondent either through telephone, call, short messages, SMS, or email, or any other available medium, and both parties shall agree on the arrangement for visitation and access. The petitioner shall also participate in all parental activities in the school without restrictions. The petitioner shall pay the school fees of the children per term or per session up to university or tertiary level of education. The petitioner shall pay the respondent the sum of 100,000 naira monthly for the maintenance and upkeep of the children. The petitioner shall pay all medical expenses of the children in the event of sickness or subscribe to a health management organization for the health needs of the children. The respondent shall give reasonable notice to the petitioner of at least 1 month prior to relocation to a new address in order to keep the petitioner informed of the whereabouts of the children. The respondent shall allow the petitioner to bring the children to his house whenever he desires, whether during long vacation or whenever he desires intimacy with the children. None of the children of the marriage shall be taken out of the petitioner's immediate environment, which is Lagos State, without adequate notice duly forwarded to the petitioner a month earlier, where the movement is within Nigeria, and 3 months earlier, where the movement is outside the country. Both parties shall maintain peace and provide a conducive atmosphere for the growth of the children during meetings and pickups. Any of the parties may apply for an upward review of the maintenance sum where circumstances change, pursuant to Order 73 of the Matrimonial Causes Act, laws of the Federation 2004. That is the judgment of the court. All right. I'm going to rise and then for a few minutes and then I will come back.
Ecco, non posso fare.
I don't know how to stop the video.